did it? We don't know. Just let the evidence show. Who did it? We don't know. Just let the evidence show.
Imagine this. A fatal stabbing takes place outside a club. A witness sees a suspect running away. The Gardaí arrive within minutes. There is blood on the pavement. There is a broken bottle nearby with blood on the jagged edge. The body of the unfortunate victim has been covered with a sheet, but the pool of blood has spread too far to cover it all. Several people have come out of the club and are standing around looking at the scene. A CCTV camera is pointing directly towards where the assault happened. At that moment, every decision matters. If evidence is lost, damaged, contaminated, moved, or ignored, the truth may never be discovered. Today we are looking at one of the most important parts of any criminal investigation, the preservation of the crime scene and the collection and preservation of evidence. In this video, we will examine what a crime scene is, why preserving it matters, the powers of the Gardaí to protect a crime scene, how evidence is collected, how evidence should be preserved, what happens when evidence is lost, and the legal consequences of failing to preserve evidence. Let's begin. A crime scene is more than simply a location. It is a source of information. Every object, mark, stain, footprint, fingerprint, or electronic record may help answer important questions. Who was there? What happened? When did it happen? How did it happen? Who is telling the truth? Physical evidence is often more reliable than memory. Witnesses can forget. Witnesses can make mistakes. Witnesses can lie. Evidence cannot tell us everything, but it can often tell us for more than people can. That is why the first priority of investigators is to preserve the scene exactly as they find it. Under Irish law, a crime scene can be formally designated under Section 5 of the Criminal Justice Act 2006. A superintendent may designate a place as a crime scene where an arrestable offence has occurred, or there is evidence relating to such an offence and that evidence needs to be collected. An arrestable offence is any offence that carries a potential sentence of imprisonment for 5 years or more. Once the location is designated as a crime scene, Gardaí gain specific powers to protect the area and preserve evidence. Importantly, Gardaí do not have to wait for formal designation before acting. Section 5 allows Gardaí to take immediate steps to preserve evidence where they reasonably believe an arrestable offence has occurred or evidence may be present. In practice, this means action begins immediately. Time lost can mean evidence lost. The first Gardaí arriving at a scene have a crucial role. Their job is not usually to conduct a full investigation. Their job is to protect the scene. The first priorities are often to save life, to protect injured persons, to identify immediate danger, and to preserve evidence. This can be a difficult balancing exercise. If a victim requires emergency medical treatment, saving their life comes first. However, Gardaí should still be conscious of preserving evidence wherever possible. For example, noting where items were found, recording movements, and identifying people entering or leaving the scene. Once immediate risks are addressed, attention turns to protecting evidence. A crime scene must be secured. Why? Because contamination is the enemy of evidence. Every unnecessary person entering a crime scene creates risk. Footprints can be destroyed. Fingerprints can be smudged. DNA can be transferred. Objects can be moved. Electronic devices can be altered. Under Section 5, Gardaí may mark off an area, erect barriers, place notices, direct people to leave, and prevent people from removing items from the scene. This is why we often see crime scene tape, barriers, and restricted access zones. The goal is simple: protect the evidence from interference. At the same time, a crime scene is often located on or in private property. The right to private property is protected by Article 43 of the Constitution. This means that the Gardaí cannot remain on site indefinitely, as this prevents the owner from exercising their right to that property. For this reason, the crime scene designated by a superintendent only lasts for 24 hours if that site is on private property. In most instances, 24 hours is sufficient time to gather all relevant evidence from the crime scene. However, if 24 hours is not sufficient, the Gardaí have two ways to extend the crime scene period. They can apply to the district court for an order to preserve the crime scene for a further 48 hours. This can be done 3 times, which means the district court has the power to extend a designation for a total of 6 days. In exceptional circumstances, the Gardaí can apply to their High Court. Their High Court can make an order for any period that it considers appropriate. The period will be specified in the court order. The owner of the private property can go to court to object to the order. It is unlikely the court will refuse to grant the extension order, as it is in the greater public interest to allow the crime scene to remain intact. However, the court may attach certain conditions to the order, like allowing the owner supervised access. Before evidence is moved, the scene must be recorded. Think of it like freezing a moment in time. Investigators usually create a permanent record through photographs, video recordings, sketches, measurements, and written notes. Every item should be recorded where it was found. A photograph taken before an object is moved may later become extremely important. Once an object is moved, the original scene can never be recreated perfectly. That is why documentation comes first. Evidence comes in many forms. Physical evidence may include fingerprints, DNA, blood, hair, fibers, weapons, clothing, footprints, and tire marks. Modern investigations also involve digital evidence such as mobile phones, computers, CCTV recordings, social media records, and text messages. Forensic Science Ireland is an associated office of the Department of Justice. Originally known as the Forensic Science Laboratory, FSI was established in 1975. It provides a scientific service to the criminal justice system by analyzing samples submitted from crime scenes and providing expert evidence in criminal trials. But these scientists are dependent on what is collected at the crime scene. And so investigators must think broadly. Evidence is not just material that proves guilt. Evidence may also point towards innocence. That distinction is extremely important. The Irish courts have repeatedly emphasized that Gardaí have a duty to seek out evidence. This duty does not only apply to evidence that helps the prosecution. It also applies to evidence that may help the defense. One of the most important Irish cases is Bradish versus the DPP. Judge Hardiman stated, "It is the duty of the Gardaí to seek out and preserve all evidence having a bearing or potential bearing on the issue of guilt or innocence." Importantly, he added that this duty exists whether the prosecution intends to rely on the evidence or not. That is a powerful principle. The aim is not to secure convictions. The aim is to secure justice. The Supreme Court further clarified and embellished the principles it set out in Bradish in the case of Ludlow versus the DPP. On 8 October 2002, Ludlow was driving a truck which collided with an oncoming car, causing the other driver to suffer serious injuries from which he later died. The accident occurred on a wet and greasy road. Witnesses said neither vehicle appeared to be traveling at excessive speed. The truck allegedly crossed onto the wrong side of the road before the collision. A Garda Public Service vehicle inspector examined the truck shortly after the accident. He concluded that 2 tires on the rear axle were excessively worn and that this defect would have contributed to the loss of control of the vehicle. Ludlow was later charged with dangerous driving causing death. Additional charges relating to the condition of the tires were added. Before the trial, Ludlow's forensic engineering experts sought access to inspect the tires and vehicle. However, the Gardaí had already allowed the tires and relevant physical evidence to be destroyed. As a result, the defense expert could not conduct an independent examination. The prosecution intended to rely heavily on the Garda inspector's opinion that the worn tires caused or contributed to the accident. The defense argued that without access to the actual tires, it was virtually impossible to challenge that expert conclusion effectively. The prosecution argued that the Gardaí did not have the facilities to hold onto large objects of evidence indefinitely. The Supreme Court upheld the High Court's decision restraining the prosecution from proceeding. The court held that the Gardaí had a duty to preserve and disclose material evidence which had a potential bearing on the issue of guilt or innocence, as far as was necessary and practicable. The duty to preserve and disclose could not be defined precisely as it was dependent on all of the circumstances of the case. The duty did not require the Gardaí to engage in disproportionate commitment of manpower and resources. The duty had to be interpreted in a fair and reasonable manner based on the facts of a particular case. Instead of keeping large physical objects as evidence, the court suggested that it might be reasonable in certain circumstances for the Gardaí to have a forensic report on the object. In general, an accused person, his lawyer, and an expert witness should be given an opportunity to examine such evidence. If the evidence no longer exists, the reason for its destruction was part of the factual matrix, but it was not a determinative factor in the test to be applied by the court. These principles were subject to the fundamental test to be applied by the court, namely, whether there was a real risk of an unavoidable unfair trial. Once evidence is identified, it must be collected carefully. Every type of evidence has specific procedures. For example, a blood sample must be packaged differently from a firearm. A mobile phone must be handled differently from a fingerprint. The key principle is preservation. Evidence should be collected in a way that prevents damage, contamination, deterioration, and loss. Each item should be properly labeled and recorded. The investigator should be able to explain what was collected, where it was found, who collected it, and when it was collected. Accuracy matters. Small mistakes can have major consequences. One of the most important concepts in evidence preservation is the chain of custody. This simply means keeping a clear record of everyone who handled an item. Imagine that blood-stained bottle recovered from the crime scene. As the victim's throat was slashed, this is a possible murder weapon, which might also have fingerprints on it. The prosecution must be able to show who found it, who packaged it, who transported it, who examined it, and where it was stored. Without that record, questions arise. Was the item altered? Was it contaminated? Was it even the same item? A proper chain of custody protects the integrity of the evidence. The Gardaí use a system called the Property and Exhibits Management System, PEMS, and later PEMS2, to electronically track exhibits in Gardaí custody. The system was developed to provide investigators anywhere in the country with a single view of property and exhibits held by the Gardaí, and in so doing, to improve accountability and traceability. PEMS records information such as exhibit reference numbers, storage locations, movement of exhibits, transfers between Gardaí members, transfers to specialist units, and returns, disposals, or court production. This creates an electronic audit trail in addition to the traditional exhibit documentation. Collecting evidence is only half the job. Evidence must also be preserved. The courts have repeatedly stressed this obligation. Evidence relevant to guilt or innocence should be preserved so far as is necessary and practicable until the trial process is complete. This obligation extends beyond obvious evidence. It can also include material that may lead to other relevant evidence. The duties of the Gardaí therefore include finding evidence, preserving evidence, retaining evidence, and making evidence available where required. Modern cases often involve CCTV. CCTV footage can be extremely important. It may identify suspects. It may support or contradict witnesses. It may even prove guilt or innocence. The Irish courts have repeatedly dealt with cases where CCTV footage was lost or not preserved. The lesson is simple. If potentially relevant CCTV exists, investigators should move quickly to secure it. This need for haste is because many CCTV systems automatically overwrite recordings after a short period. Evidence lost today may be gone forever tomorrow. Evidence can be lost in several ways. It may be destroyed, misplaced, released to third parties, overwritten, or simply never collected. When this happens, courts ask an important question: has the accused been deprived of a fair trial? The focus is not on assigning blame. The focus is on fairness. Would the missing evidence have provided a realistic line of defense? Could its absence affect the ability of the accused to challenge the prosecution case? If the answer is yes, serious consequences may follow. Courts may exclude other evidence that was reliant on the lost evidence, give warnings to juries, criticize the investigation, or even halt a trial altogether. In exceptional cases, prosecutions have been prohibited because critical evidence was lost. The courts have made it clear that missing evidence can undermine confidence in the fairness of a trial. That is why preservation is not a technical detail. It is a fundamental part of justice. Good investigators think ahead. They ask, could this item become important later? Could the defense want to examine it? Could an expert need access to it? The courts have repeatedly encouraged the Gardaí to preserve potentially relevant evidence and, where appropriate, allow defense experts an opportunity to examine it before disposal. Good preservation protects everyone. It protects victims. It protects suspects. It protects witnesses. And it protects the integrity of the criminal justice system. The preservation of a crime scene is about protecting the truth. A crime scene is fragile. Every footprint, every fingerprint, every drop of blood, every CCTV recording, and every witness statement may become important. Irish law gives the Gardaí significant powers to secure crime scenes, seize evidence, and preserve material for future court proceedings. But with those powers comes responsibility. Their duty is not merely to gather evidence that proves guilt. Their duty is to seek out and preserve evidence that may reveal the truth, whether that truth supports the prosecution or the defense. Because in the end, the goal of the criminal justice system is not simply to win cases. It is to ensure that justice is done. This is Declan O'Luder QC on The Law is My Oyster. Mind yourself now. Until next time. Shlan.